you who are in the room and not speakers, anytime you have a question or comment, just raise your hand. I'm watching you all. This is why I'm standing, and I'm keeping the queue if there is any. We are going to talk today about criminal justice in cyberspace. We have a long tradition at EuroDIG having sessions on cybercrime, but we personally think that the term cybercrime is not applicable anymore. It's too narrow because any crime nowadays can leave digital traces. So that the same instruments that we use to investigate cybercrimes are nowadays used to investigate basically any crime. And law enforcement urgently needs access to data. How do we solve this problem? If you look at the recent political context, you will see that from both sides of the Atlantics, we have various proposals on how to make life of law enforcement easier and facilitate access to data without, for example, judicial authorization. We see Cloud Act in the US, and we see European proposals for EEvidence regulation, which basically change the current system of mutual legal assistance where request to data has to be approved in both countries. Under new proposals, they will be sent directly to internet providers without the need for approval. How do we deal with this? Criminal justice on cyberspace, more of everything, less of everything. What do we need to solve the problems, and are we going the right way? And I have really, truly amazing panel who is going to discuss this together with you. So just from my right-hand side, we have Philip Aman from the Europol Cybercrime Center, EC3. We have Marco Kunapu from Ministry of Justice of Estonia. We have Stanislav Tosha from the University of Utrecht, professor. We have Paolo Gracia from ETNO, European Network Association of Telecommunication Providers. And we have Akadia Sineza from Google. So welcome all of them. And I will start with Marco, who probably can give us a short overview of those proposals about access to electronic evidence and tell us where they're good, where they're bad, what they bring for law enforcement, and what is his perspective on this. Marco, the floor is yours.
Okay, thank you, Tatiana. Good afternoon. First, I think that it's not going to be a surprise to you that in order to investigate criminal offenses, not only cybercrime, but any offenses, you need access to computer data. You need access to electronic evidence. Problem is that often when people use the services offered by different service providers, the question is that sometimes we know that the data is in our own territory, and we can use sort of, let's say, domestic procedures, which won't be a big problem. But often computer data that we need to use as evidence in criminal proceeding is stored somewhere abroad. And so far, the cooperation between the states, cooperation between law enforcement and service providers, it has worked to a certain extent, but it's not perfect. There are some flaws, there are some problems, and all this have created quite great challenges, huge challenges for the law enforcement authorities all over Europe. I could also say that all over the world. And so therefore we need something additional, something actually which would, I wouldn't say replace, but maybe complement existing mutual legal assistance frameworks and also those cooperation frameworks that are based on voluntary cooperation. So therefore, actually right now, both European Union and then Council of Europe have been working with additional solutions, with new proposals. And again, the idea is to provide new binding legal framework that would enable law enforcement authorities in one country to access or to obtain electronic evidence in another country. And of course, both instruments need to have to provide for procedures, conditions and safeguards, as well as remedies. As regards the Council of Europe, then discussions on the second additional protocol to the Budapest Convention, Convention on Cybercrime, have been taking place for years already. And since 2017, the committee, Cybercrime Convention Committee, has been negotiating and then drafting the text of the protocol. Nothing has been agreed, nothing has been finalized yet, and then work is still going on. Last year, also, European Union came out with a so-called EEvidence proposal, which consists of regulation and then directive, and also the main purpose idea is to provide binding legal framework that would enable EU law enforcement authorities to get more easily data from service providers who often are not located in our own territories, but in other countries. But again, the connection, the link is that they are offering services online, people are using them, and then if it happens to be, I don't know, victim or suspect, then we need this information. Right now, it is to some extent possible to get this data from abroad. As I mentioned, the voluntary cooperation regime exists to a certain extent, but again, it's not working perfectly. And when we talk about MLA, mutual legal assistance, then again, it is slow, it is too bureaucratic, and again, those cooperation regimes, frameworks that had been developed decades ago, they were not designed to address electronic evidence, and then therefore, in order to meet the current challenges and then technological developments, in particular cloud computing, we need something additional, we need something new. And then this is what both European Union and the Council of Europe have been doing.
Thank you very much, Marco. If there are no immediate questions or intervention, I would like to pass the floor to Paolo. Paolo, I know that ETNO had really strong position on the European e-evidence regulation proposal. I picked a couple of points from Marco intervention, from Marco introduction. Do you think that these frameworks really would complement mutual legal assistance, and what, from your perspective, this more easily access to data means? I think that this is basically what ETNO was trying to reflect on. So could you provide us with your perspective? Thank you.
Yes, thank you, Tatiana. And for whom the people that don't know ETNO, we do represent European telecoms operators, network operators. So the companies like Deutsche Telekom, KPN, Orange, Telefonica, and we think our voice around the table is pretty important for two orders of reasons. First is because we do have a pretty long-standing history of cooperation, of mandated cooperation with law enforcement authorities, and second, because the information carried through our networks is pretty relevant to law enforcement. And to pick your point, I would like to also note one element of the two elements, actually, of the impact assessment of the European Commission attached to the proposal. The first element is that 90%, roughly 90% of cross-border access requests are addressed to five companies only: Google, Microsoft, Facebook, Apple, and Twitter, which means that this proposal is originally designed to solve issues in accessing data stored by five companies, but impact is much broader than that. And the second one is also that refers to the earlier intervention, is that the impact assessment knows that the problem is that these companies and the storing capacity of these companies may not be based and distributed in all countries or European countries, but they may avail themselves of centralized storing system. And that's where ETNO perspectives kicks in, because as telecoms operators, we do operate very much nationally, and we are conscious that this proposal would impact majorly telecoms operators because of the importance of the data carried over our networks. But at the same time, we do have a history of mandated cooperation with local authorities, because attached to our license to operate of our members in European markets, there are obligations to disclose data and collaborate with law enforcement authorities. And that's a system that has been in place for a long time and works pretty well. Indeed, every request of access to data, be it access to data, lawful interception, needs to be based on a legal order by national authorities. And usually this legal order has to be communicated to the provider through a series of standards, code of conduct, MOUs, service level agreements, and technical specificities that sound like details, but they're not, because with the EEvidence proposals, if a telecom operator were to be exposed to requests from 27 or 26 other member states, that means that telecom operators would have to put in place secure channels of communication, accreditation, and standards with 26, 27 member states, which is, well, a bit unfeasible. The European Commission, in their defense, said that they've been working with member states on development of the e-Codex platform to secure a centralized system of communication. But this is kind of the chicken of the egg. Do we want the legislation first and then think about the technical solution, or do we want to have a technical solution for once the legislation in place? Because once legislation in place, companies have to abide by legislation. But my point that I would like to stress before then leaving the floor to the others is that at the core of our position, for all the considerations that I mentioned above, is that territorial jurisdiction is the key. It is really has been at the core of the collaboration with authorities to whom our members interface. It is what guarantees that, as I say, there are standards, there are secure channels in place that make us comfortable that a legal order is based on a legal basis, and that respects also the fundamental rights of the concerned people. And the more we do stretch the boundaries, the limits of territorial jurisdictions, the less secure this collaboration becomes, just because operators can't ensure that the same standards can be applied to collaboration with 27, 26 member states. So I would just like to leave you with that. Our core message is we do commend in part the objectives of the evidence proposal. We do understand the challenges of law enforcement, prosecutors, and the judiciary, but the system of collaboration from the telecom perspective is working pretty well, and we shouldn't risk breaking it by trying to solve it.
Thank you very much, Paolo. I see a question. One moment, I'm going to bring the microphone.
Great. Thank you very much. This is Luis van der Laan. I'm now working at EuroJust, but in my previous capacity, I was working with ICT Netherlands, and there for Digital Europe also had a very strong position on the EEvidence directive. And you're being very diplomatic, but do I understand your concerns to basically mean that because in certain EU member states there's a different level of protection of fundamental rights and the rule of law, for example, one of the member states is actually being investigated by the European Commission, and that therefore some of your members, telco operators, would be uncomfortable passing information, but because in the EEvidence says, well, you can then start a case and say, well, actually, I don't want to do this. I mean, the telco that I know best told me they will never do that and they're just going to hand over the information. So I was wondering, because I'm not familiar with your strongly worded opposition to the evidence directive, could you give us a little bit less diplomatic, maybe you're in Holland, more Dutch way of saying what's wrong with it?
Paolo,
Yeah, sure.
please.
And I will. I think because of what, I also they mentioned all the safeguard, etc. Usually, telcos do not opine on the orders they do receive. They just receive. They are comfortable that they are legal, and they just execute. There is, according to transparency reportings, but also interviews with our members, there is a very negligible share of requests that gets rejected just because the legal basis is not correct enough, or just because of formal problems, because members know that they do not have to carry out the legality check. If a Dutch operator would receive a request from Polish authorities, from Spanish authorities, who would ensure that the legal basis and the legal safeguards are equivalent to those in place in the Netherlands if they are not validated by an authority in the Netherlands? There are some also reassurances given from the Commission that operators do not have to carry out a proportionality check, legality check, just have to execute. But that's not how it happens in practice, just because if some violation of the fundamental rights happens, in the end, the liability would be upon the operator. So that's the point. And also, that's what makes members uncomfortable. And then there is also a host of various practical questions. For example, emergency procedures, disclosure in 6 hours. They it's much tighter than the timing that is afforded by their national authorities. So they may find themselves in the situation of having to give privilege to the request that comes from a foreign authority than to the request of the home authorities, which would be a bit ironic. So there are many let's say misgivings, and what I missed to mention in our in my intervention is our proposal is to bring back the process closer to the authority, to the national authorities. So to have a stronger involvement of the authorities in the member states where the telco operates, so that the telco, the national authorities act as an intermediary between the foreign one and the operators remain sure that the requests that land on their desk are validated according to their legal standards.
Thank you very much. And I would like to give the floor to Arcadia Sineza from Google as one of the 5 operators to whom the requests are going to actually be directed. Are you comfortable with this proposal?
Google is, by the nature of its technology and by the designation of Google LLC as a U.S. entity, situated wholly differently than certainly the European telco operators, and has a different perspective with respect to the EEvidence proposal. So with respect to the EEvidence regulation, Google on the whole supports the regulation. Google supports modernization of cross-border access to user information. This regulation is a significant step forward in modernizing and harmonizing cross-border access within the European Union. Before the EEvidence regulation, this kind of a framework did not exist. And it is true that what that meant for companies like Google, who are based in the United States, who are subject to US law, is that Google was left to navigate conflicting legal obligations, different patchworks of legal requirements across Europe, and Google historically has always exercised its ability under US law to disclose certain categories of information directly to European authorities. And we have only done so if we were sure that the request that Google received was valid and otherwise met the requirements of the issuing jurisdiction. So if you can imagine, that left Google in the position of having to understand the local and national requirements of every jurisdiction in Europe. And we actually have quite an internal library of what all the requirements are and all the different jurisdictions. But for Google's perspective, having those requirements harmonized, accompanying those harmonized requirements with safeguards, albeit a side comment here, the safeguards contained in EEvidence, I think, certainly could be improved, most notably on the notification measures, and I'll come back to that in a minute. But on the whole, EEvidence is, like I said, a significant step forward in creating a harmonious framework across Europe. That said, I think there are provisions of EEvidence, and Google published a position paper on the Commission's text for the EEvidence regulation. But as it's evolved, there are portions of the regulation, most notably a penalty provision, that I think create disincentives for companies to ever question the validity or the sufficiency or the propriety of a law enforcement request. So what I mean by that is under the current text that contains a severe penalty for non-compliance, what that does is incentivize a service provider to always produce data and to never question. Not that service providers want to be in a position of having to question or confirm the validity of a European production order, but that to the extent that a provider might have uncertainty about a request, they would choose to disclose rather than raise an objection, rather than face that penalty. So one of the things about the EEvidence regulation is that and I think it's not necessarily a bad thing, but in an effort to modernize legislation, in an effort to give law enforcement expeditious access to data, as they should have when they're conducting legitimate law enforcement investigations, many of which are time sensitive, and in recognition that the MLAT processes are too slow, too antiquated, and too difficult, EEvidence solves those things. But because EEvidence creates a mechanism by which an issuing authority can go directly to a service provider outside of its jurisdiction, it has eliminated the role of normally what would be the central authority in the receiving jurisdiction. Having eliminated that role, some of the obligations of the central authority has now shifted to the service provider, or having not shifted, has eliminated sort of the check that a receiving jurisdiction central authority would otherwise do. Coming back then to the notification piece, that can be solved by robust notification measures. So at the moment, the EEvidence regulation effectively prohibits service providers from notifying their users or customers about the existence of a demand. Google thinks that notice should be the norm, and only by exception should notice be prohibited. The reason is that a user or customer is best positioned to evaluate if any of their fundamental rights or privileges are unlawfully implicated by the request. But another notification procedure could simply be that any issuing authority has to notify the central authority of an impacted member state, meaning that if I'm the issuing authority in France and I'm seeking information about a German user, as the issuing authority, I would have to notify the German authority, and the Germans could themselves decide whether or not to intervene in the request and assert any objections. This would place back to governments the role of evaluating the propriety of the request, and the one way to do it in the regulation is to create that notification procedure. So I could go on all afternoon. I'll stop. But with that, on the whole, we think this is a good step forward. We think that the EEvidence regulation could help support and serve the foundation of an EU-US Cloud Act agreement as well. And I think both of these instruments are positive developments in terms of modernizing surveillance legislation.
Thank you very much, Arcadia. And we focused a bit on the role of providers and on the power of providers and responsibilities of providers. And I want to give the floor to Stanislav Tosha, who might provide us with some more meta level of the criminal procedural law, human rights and safeguards from his perspective.
Thank you, Tatiana. Is it working? Thank you, Tatiana. I want to bring to the table a legal concept which hasn't been mentioned yet, but picking up also from what Arcadia just said, which is mutual recognition. And I understand this is not a forum to discuss criminal law concepts or concepts of international cooperation, but let's not forget this instrument is based on mutual recognition as an idea, and the legal basis is mutual recognition. It's the Article 82, which allows the EU to create instruments which are based on the principle of mutual recognition. And what is mutual recognition? It's a step forward from mutual legal assistance, meaning that one member state in principle recognizes the validity of a decision of another member state. This is the idea. In practice, European arrest warrant, this is the classic instrument of mutual recognition that has been working for the past more than 15 years quite well, which means a French authority issues a European arrest warrant to get somebody from Germany, sends it to Germany, and the authorities in Germany do just a basic limited check of this order and then send the person to France. This is the idea. Now here, what happened is that we got rid of the authority in that state. I claim this is a quantum leap of mutual recognition and mutual trust for two reasons. One reason is that the grounds for refusal are limited in this proposal, are much more limited. If the authority is engaged, which as we know happens in case there are problems with the execution when the service provider resists the order, then the authority of that country can come back, and then they have some grounds for refusal, much more limited than in the other mutual recognition instruments like European arrest warrant or European investigation order. But what is more important is that what Arcadia said is that the order goes directly to the service provider, and in principle the service provider should send the data, and nobody is checking it. If they do send it, the authorities in that country are not engaged. What it means is, as you said, the Commission, the proposal, the explanatory memorandum can say that the service providers have nothing to say. In theory, yes. In practice, no. Because they work, in my opinion, but this is what I just heard, according to a different logic, which is a business logic. There is a need to check, is it good for us to provide this data? Or whether we might suffer reputational consequences that make it not worth, but it's better to risk the sanction. Poland was already mentioned. It's not the only problematic country at the moment. But Spain, you said Spain. If Spain starts to send requests to Belgium about the leaders of the Catalan independence movement, and then you have NGOs that gets very active, they will have to take a decision. What's better for us? How should we look in front of the society? So I think we can say that they have nothing to say. We can even shield them from liability by saying that by complying the orders, they will not be liable. But in practice, they also need to think about their reputation. And this changes the whole logic. And this makes them sort of guardians of fundamental rights. But according to the business philosophy, and I think this is a huge change, which is not fully reflected necessarily in the debate yet. Because do we want service providers to be guardians of the fundamental rights instead of the member states?
Thank you. Thank you very much, Stanislav. And Philip, I will give the floor to you, like bringing it back to law enforcement. What do you think about these proposals about direct requests for data?
Thank you, Tatiana. It's great to be here and represent law enforcement on this panel. If I just may take a moment to take a step back and I want to refer to a paper that we are currently drafting the third version together with our colleagues at EuroJust, where we describe the common challenges in combating cybercrime for law enforcement and the judiciary. Now, you have these basic categories. There's loss of data, related to the criminal abuse of encryption, criminal abuse of cryptocurrencies. It's loss of location, so loss of data, loss of location, criminal abuse of networks like Tor. It's cross-border cooperation. It's legislation, obviously. For us law enforcement, it's also capacity building, having the skills and whatnot. It's public-private partnership. So actually for us, this is one of the aspects that makes our work difficult. And so EEvidence, we support it. We are not obviously an agency that develops legislation. We're happy if we get invited and can provide sort of the view, the boots on the ground, let's say, and see what the challenges are, and hope that the legislators can come up with something that meets the practical requirements, but at the same time, as we heard, has all the safeguards in place to make sure that we protect the fundamental rights, protect human rights, because that's really what it is. I mean, from our standpoint is we investigate criminal activity. We're not into bulk data surveillance. We're not into eavesdropping. We don't need to have urgently access to data. That's not the point. We have a criminal investigation, and as part of that investigation, especially when it's cybercrime, but as you said, any type of criminal investigation these days has a digital component, and sometimes that digital component is the starting point of the investigation. So that might be an IP address. So we need to have the means to be effective and efficient while respecting the fundamental principles, and we heard them before: proportionality, necessity, legality. So, and I appreciate, I think those are all valid comments. We don't want to take away any checks and balances. We want to make sure that the process respects the human rights, but at the same time supports our work. But I think from where we stand, and we can then talk about also some of the challenges and potential solutions legislation is a huge challenge for us, and something that we closely monitor, because obviously that's one of the, well, if not it's the basis for our work. But it's just one. So when we talk about EEvidence, it's just one of the challenges that we see. So I think that might be useful to see that we're sort of looking at different things. And then if you look at e-privacy is a good example where in its one of the first sort of proposals would have left us in a situation where a lot of our partners wouldn't have been able to scan attachments. So we have an existing process with the US, with the National Center for Missing and Exploited Children, and they send us reports of child sexual abuse material. It's a huge volume challenge. We can discuss that at a later stage. It's a real big data challenge. But if some of the big providers would have to implement e-privacy in one of the previous reading, it would have meant that it would have not been able to scan for any attachments that we can done. So this is where it's important that we have a voice as well, and then we can say, well, these are the implications. Please do consider those things. But in general, just to make that point, it's one of the challenges that we face.
Thank you very much. Are there any questions for now? Yes?
Not necessarily a question, but representing the Council of Europe Cybercrime Program Office in Bucharest, we've heard a lot so far in the discussion, maybe it will come up later as well, about the EU EEvidence proposal. But since we are still at the stage in the discussion where we talk about regulations, I'd like to hear a bit more about the the Budapest Convention on Cybercrime of the Council of Europe. And why I make this point is because in February we organized in Bucharest under the Romanian presidency to the Council of the EU, an international conference on criminal justice in cyberspace, concluded with key messages that are available on the Council of Europe website, the Cybercrime Program Office. And one of these key messages, about 20 of them, but one of them was in line with the harmonized approach that was mentioned, and also the other points that were made, that the Budapest Convention is still one of the international convention that is mostly agree with, and it has so many member states that have already signed and ratified it, and it's considered as a good instrument. And I'd like to hear from your perspectives also one key message is with this in mind, to see if the conclusions from this conference are in line with the thoughts of the panel and of the participants here as well.
Thank you very much. And anyone has an intervention on this? Because we basically, I'm not here to state my opinions, but I do agree that Budapest Convention is a very important instrument. Arcadia?
I'll just respond briefly for Google. With the caveat that we have not seen a draft text and actually ourselves aren't sure what's being contemplated in the negotiations of the second additional protocol, I would just echo that, again, to the extent that the Budapest Convention is looking to modernize and create safeguards and harmonization and procedure around cross-border access, that's a good thing. One of the really great things about the Budapest Convention is it has a really strong jurisdiction provision in Article 18, which, by the way, EEvidence regulation, or at least the proposed regulation, does not. So the Budapest Convention continues to respect sovereignty and jurisdiction in a way that the regulation arguably has a more aggressive extraterritorial reach. But with respect to the mechanisms being contemplated, I think any mechanism that involves government-to-government interaction is a preferred path forward, even if it's an expedited, light framework around mutual legal assistance for perhaps subscriber data only.
Thank you very much. And Marco, yes, I really wanted to give the floor to you just to address those concerns, mild concerns and strong concerns expressed, because I know that you have a lot to say about EEvidence and you have something to address those concerns. So please, just the floor is yours, either on Budapest Convention or on what has been said earlier.
Okay, thank you. Actually, those points and concerns that were raised, yes, these are really important ones. And all of them also have been discussed both in Brussels and then in Strasbourg. Because this is something actually we need to just take into account and bear in mind, both while negotiating the EEvidence proposal as well as drafting the text for the second additional protocol to the convention. And of course, actually, the scope of those instruments, it's a bit different. EU regulation is for EU member states, but the second additional protocol would be for the more wider audience. And as I can say, for example, right now the Budapest Convention has 63 state parties to the convention, and then so far it is the only legally binding international instrument on cybercrime and electronic evidence that has global impact. So we have state parties who are actually sharing the same standards concerning substantive law, procedural law, international cooperation in all continents of the world. But as regards those points and concerns that were raised, first, yes, we have been discussing a lot about notification, actually, whether to notify, and then in case notification takes place, then whom? It's not very difficult. It's quite difficult to answer this, because when we also think about impact, I don't know, to interest of the service provider, impact to data subject, then, for example, if we imagine a situation that we have a victim in Estonia, we have a suspect in Finland, for example, Finnish police is investigating the case. They would need some data from a service provider that is not based in the European Union, but has, for example, a local office representation in Ireland. Then, yes, we could easily actually send this notification to Ireland. But actually, what would they do this? Because they have actually no idea what the case is about. Often it is the case that we don't even actually know who the suspect is beforehand, because we just see that we see that somebody is using IP address, or somebody is using some sort of email address or nickname, and But again, this could be all, and then this is usually the case when we talk about the very first stages of the criminal investigation. So therefore, if notification takes place, then actually what should be the follow-up? Because if there will be notification, if somebody, I don't know, competent authority in a receiving state would get this, then I think this notification also entails certain responsibility or maybe obligation, and then again actually it would be quite difficult for the competent authority in the receiving country to decide whether preservation of data or disclosure of data is necessary, justified or not, because they don't know what this is all about. Also as regards conditions and then safeguards, when we talk about European Union proposal, then it's regulation. It will be directly applicable and actually same conditions, same rules for all member states. And it's not only this e-evidence proposal, because also member states, the legislation in member states also has been harmonized by other instruments as well. For example, on procedural rights, there are also instruments concerning substantive law, etc. Of course, for the Budapest Convention and second additional protocol, it would be a bit different, but again, as we are talking about some measures which are maybe not so, let's say, traditional, conventional, which actually go beyond the existing Budapest Convention as well, then again, we need to just pay attention to additional safeguards and then conditions. And then this is actually has to be, because yes, we would like to actually trust each other, we would like to trust other state parties of the convention, but still you need to have some conditions and safeguards in place as well. And then, of course, when something goes wrong, it happens to be the case that, I don't know, that there are member states or state parties who just would like to abuse those powers, then again, actually, there are some mechanisms for the Budapest Convention. We have Cybercrime Convention Committee actually to address those issues. And then if something actually goes wrong and then somebody abuses certain powers at the European Union level, then also there are also some supervisory and then the places in place actually where you can actually raise these issues and then discuss.
Thank you very much. Are there any questions? So then I would like, unless one of you wants to respond something to Marco, I would like to, oh, sorry, I'm running again with the microphone, first here and then to Luis Wies.
Yeah, I'm Michael Vos. I work for Microsoft. So I can, we can find ourselves in the arguments of Google as well. So when we're talking about service providers being the guardians of the human rights, I think we do not want to do this. The same as with the telcos, of course. But what we do want is if we see a production order and we see that it's too broad, abusive, let's say you need to have the data of one person who works at a company, and the production order asks all the emails of one domain. Then we want to say, well, we want to give you the data, but you should sort of adjust your order to make sure that it's more directed. So this is not a liability for a service provider to be liable for checking the fundamental rights of an order, if it complies to fundamental rights. But if it's too broad and too abusive, but we do want to give the data, then we want to have this possibility to make it more directed, so to say. So I don't know what your view is on this part, but we think it's unnecessary to give more data than necessary.
One moment before I see that there's some interactions from the panel, but may I ask you a bit of provocative question as a moderator? So I'm citing you, maybe not literally, if we see that the order is broad and abusive. So basically, you say that you are assessing the order in any case.
Well, there's a difference. If you assess it on fundamental rights, that's different than saying, okay, so you're not checking if the order is compliant to fundamental rights, because this is the role of a local judge. If the judge says this is, who sometimes does not have the technical knowledge or the technical information, maybe the knowledge but not the information, then we can say, all right, the judge said that this is compliant to human rights, but we still think that you can get the data without having more data than necessary. So we're not judging the choice of the judge, but we're only saying, well, in this case, and these are cases that happened, and then they can say, okay, we create the order again, but now it's more targeted to the data that we actually want. That's not judging human rights, right? Yeah.
Thank you, and we will get to the next question soon, but first, any direct responses to this? Stanislav, I saw your hand up.
I actually had a very similar reaction to yours. Like, you see an abusive order or a dubious order, and then you want to comply with it, but you just want to have some, precision. Like, what do you mean by that?
Okay, so let's say you see the order, and a judge said that it's compliant to human rights. We're not going to question this. But if we see that the goal is to get the data from one subject, but they're actually asking for, let's say, the address or the information of 200 accounts, but you only want 1 or 2, then we can help them direct it to those 2 so that they don't get the information of 198 accounts that are not part of this.
I get that.
Yeah.
And then they say, it's none of your business. We want the 200. We are the judge.
Yeah,
because if you look at the statistics in certain EU member states, not to name any, but they request a lot of data from a lot of people.
Yeah.
So what do you do with that? Second question, are you happy with every judge in the European Union as it stands now, especially that some countries are under investigation about the independence of the judges?
Yeah, we do want an extra check. So we have we're on the same page as Google on this. So we think that if the target resides in a certain country, then this country needs to be notified as well. So again, it's not the role of the service providers to judge on basis of human rights. We just want to have the possibility, and not the liability, but the possibility to check on proportionality, and not proportionality as in judging on human rights, but more, okay, we see that this is the order, a judge said that it's all right to do it, so we can do it, but we just want to make sure that no more, that people who are not the target are affected by this order. That's, I think, rational, and I hope that if you're talking to to the judges or let's say the law enforcement agencies, then I think if it's reasonable, if we say, all right, you can do this order, you can execute it, but direct it more because this is the information that you actually want, then I think it's also the responsibility of a law enforcement agency to also see this point, this viewpoint.
Yeah, but as it stands, the regulation doesn't oblige the authorities to react in the way you expect.
Sure. But we just want the option to make sure that a production order is as targeted as possible.
Thank you. One moment, Arcadia, I saw that your hand was going to the microphone, so please.
I would just echo the comments that oftentimes, not because of any malfeasance, it's that the issuing authority or a judge may issue an order and not understand or fully appreciate the order that they've issued, meaning they don't understand the breadth of the data that they've authorized to be seized or the number of accounts that are subject to the order. And often there's an ability of a service provider to just sort of raise their hand and say, hey, judge, were you aware that this is what you authorized? Oftentimes the judge says, oh, no, that's not what I meant, and they revise the order. And if the judge instead says, yes, I understood, and this is what we authorized, then that's a different question. But there is a role, I think, of a service provider bringing facts to the front, to the court, to evaluate when they revisit the propriety of an order.
I will save a question for later. What if this judge is in the foreign country? But this is the question for later because we have a queue forming. Louis, with you are the next one, and then Chris, and then, yes. Oh.
And also, I'll raise the question about the capacity building of the judges.
Yeah, I have two questions. I don't know who wants to take them. First is that, I mean, Microsoft and Google are extraordinarily large and wealthy companies, and you guys could actually have the time to reflect it. But there are service providers, there are little internet providers that are literally, you know, a mom and pop shop, and there's no way they can start doing the kind of stuff that you guys are doing, and they're not going to risk the fine. So I'm wondering where their voice is in all of this. And the second thing is a thing I've never really understood about the e-evidence directive is what we call in Dutch the principle of double illegality. So let's say that you know, something is illegal in one member state but not in another, and not completely hypothetical thing whereby a very Catholic member state could say, hey, you can't get an abortion, not even in a country where it's legal, and they start getting information on something that is totally illegal in that very Catholic country, but is not illegal in the country where the abortion was actually gotten. I'm just having nightmares from, you know, it's Alabama, what's happening in the U.S. So who knows what's going to come here? What happens then, and then where are the safeguards?
So who is going to take the first question about the small providers and how they... You, Marco. Okay. Oops.
The question about smaller providers and the capacity, ability actually to handle those requests and respond in a timely manner, especially when we talk about some emergency situations and when the deadline is within hours. We have discussed this a lot as well. But again, there was some criticism concerning the text and then provisions, but in fact, no one actually could provide some working solutions. Because first, when we talk about information society services and offering services abroad, then actually how to assess whether a company is a small company or medium company or not. Because could be the case that, yes, you have, I don't know, few servers and then maybe just only few people actually working there, but you may have actually hundreds of thousands, even millions of customers. So then in this case, can you consider this as a small company, and then could this be excluded from the scope? Because it's not a secret that criminals, they know pretty well actually which companies would cooperate with the law enforcement and which not. Already now we see that many companies actually, they advertise that they are going to be bulletproof, and then if you just use our services, then actually they wouldn't cooperate with anybody, and that they don't store data and things like this. So again, it's quite difficult actually to have those exceptions. As regards, let's say, capacity building, training, yes, this is important. You need to just train. It's also just the task of the member states to provide sufficient training, not only for law enforcement, but also for judiciary. And then, yes, everybody should have certain, I don't know, baseline knowledge concerning cybercrime and then the electronic evidence. But again, in order to actually avoid these kind of situations that you would just get really broad and then confusing requests, the solution that has been discussed both at the Council of Europe and in the European Union level is to use certain formulas, certain templates. And then again, if you have those templates, then again, the chances that you would make some sort of mistakes there, that I don't know, result or just the aim actually behind the request remains unclear or confusing, actually these would be also reduced to a minimum. And then this is something actually, and then of course, when you have actually, when member states are going to implement these instruments at domestic level, again, you need to just make sure that everybody would understand actually that this is the template and then whether you should tick this box or this box if you need this or that information.
Philip, I saw your hand up.
Just in relation to the practicalities of how do you implement that, I think I can echo what you said, Marco, is I think there's a lot of power in standardizing those requests, capturing, you know, the practical knowledge and how you do those things, having forms, having templates. I mean, we've set up, for instance, the Cirrus platform, and I think one of the objectives of the platform is actually to say gives you information. How do you contact, Facebook if you want them to take down some, in this case, content, and it tells you, this is the point of contact, this is how you do it. Take EuroDIG. I don't know where they are currently with their MLAT writers tool, but that was exactly the idea. You have a tool that actually tells you, okay, if you go to this country, that provider, this is what you have to put into your request. Those are the sort of, if you will, buzzwords that you have to use so that they can legally respond to that. And I think there's a lot of there's a lot that can be done to capture also those things, and it's a link to the continuous education that not just for law enforcement but the judiciary, prosecution, and judges, so that they're aware of the implications. I think there's a whole cycle, but I fully agree that standardization and forms and capturing those practical aspects of how you actually implement that is very important.
Anyone else? Yes.
Just very briefly, I second also the request for the need of literacy preparedness of law enforcement. There is also for telecom operators that's a recurring also problem sometimes that prosecutors do not know what they ask for. So, for example, in mobile communication, they may ask for all the traffic from a given mobile cell in the past 12 hours, and then they see a throw of data coming in and say, "Oh, we didn't request for that." Yes, you did, but it's just a lack of technical understanding of what they're asking for. And standardization is crucial, but I don't think that just templates are enough, because even if you have a template, but then the authority, the police, just keeps requesting via the template all the traffic in the past 12 hours, that's not going to solve the problem. But standardization is essential, and it's not just about the request, because the request is not just a letter you do send to the operator. It's about the whole process, is how the authority gets accredited to the system of the operator to ping the system and get the request, and how the accreditation is checked by the operator, and how the request is processed internally, ultimately how the evidence is communicated technically to the authority, which is a whole process with a lot of standards, protocols involved, and that's why we do reinforce the cooperation with the national authorities is the key, because that's how you do establish this process.
So basically it echoes the comment about government to government route of cooperation. I would, for the purpose of time, I'm going to collect 3 next interventions, because I'm 4, and then get back to you. So I'm very happy that we have actually 2 law enforcement people in the queue. So Chris, you're the first. Okay. Okay, so I'm going to bring you microphone, and then 3 other.
Yes, thank you very much. Thank you, Chris, for offering up your spot. My name is Csaba Bosz, European Commission. I'm a member of the EEvidence task force that prepared legislative proposals, so I'm happy to see that this discussion is taking place with all these different stakeholders. At first, I thought it was a shame that I was not in the panel, but now with all these difficult questions, I'm actually quite happy that I'm here on the side of the table, and with Philippe and Marco and all the others taking all the difficult questions first. But I just wanted to take this opportunity to bring to the table a couple of points about some of the things that have been mentioned here this afternoon. First of all, what I would like to mention is that, of course, these legislative proposals, the EEvidence proposals from April 2018, were prepared on the basis of a very extensive impact assessment that we conducted as the European Commission. It's a very lengthy report that you can find on the internet, and it has a lot of detail about percentages of numbers of requests, how many of them go abroad, etc. So if you're really interested in this topic, and I think some of the questions that were here today can be answered if you read this impact assessment. So I would certainly recommend you to go there to our website and see that impact assessment. And what you will find there also is that we conducted quite a comprehensive consultation process to formulate the legislative proposals. A consultation process that involved law enforcement authorities from member states, from third countries, service providers, small ones, big ones, and NGOs, civil society organizations. So all of them. And on that basis, indeed, we concluded that existing channels that can be used for obtaining cross-border access to electronic evidence, like direct cooperation with service providers, but also mutual legal assistance, really do not meet the needs of law enforcement. We can also see, this is something we already concluded in 2016, but is even more the case now, that there is fragmentation at international level where different countries choose different approaches that do not necessarily overlap or have the same scope. So that puts at risk a lot. That puts at risk legal clarity, certainty of service providers, but also of citizens, and the protection of fundamental rights. So that's why we came forward with these proposals. Of course, to address all of the concerns that have been mentioned, we included quite a lot of safeguards in the proposals. Safeguards that are, I must say, and I can say that on the basis of the consultation and impact assessment that we did, are often higher than what you can find at domestic level in many European Union member states. So, for example, there is the mandatory involvement of a judicial authority, an independent authority for each and every request. And that independent authority can check the necessity and proportionality of the request before it's sent. And that's key for us. And in a lot of member states, but I'm repeating myself, in a lot of member states, you will not find this as a mandatory safeguard. So in many cases, we're actually going above what you can find in many member states. But that, of course, is to take account of the cross-border effect of these orders. I think Marco already referred to the harmonized safeguards that we can find at European Union level, for example, when it comes to the protection of personal data, the protection to the rights of privacy, but also procedural rights safeguards, which are harmonized at European Union level and therefore can also be used in the context of the proposals. So to sum up, there is really a robust framework of safeguards. We, as the Commission, of course, stand by our proposal, even though there are now discussions by the co-legislators, the Council, the Parliament, also taking into account all the opinions of stakeholders. So we, of course, are very much interested to hear that. A few points on the basis of the comments that were made. In addition, I would like to support Philippe, who indeed said that these proposals provide for investigative measures in the context of criminal law. That's something that we have to be aware of when we think about this. This is not about surveillance or intelligence. No, this is about criminal investigations where authorities, law enforcement authorities, have an investigation for a specific crime with a specific suspect, and there are safeguards provided by criminal law. And that is important to be aware of when we talk about these proposals, because a lot of the comments actually appear to go beyond that. Also, what we should be aware of is that in an overall majority of the cases where these proposals will be used, we are actually talking about domestic cases or cases that are domestic in nature. From one of the larger service providers, also present here in the room, we heard that, for example, the requests that they receive, 94% of those requests are really domestic in nature. So it's just a case where law enforcement authorities are investigating a crime with a victim in the country of the authority, with a suspect in the country of the authority. The crime happened in the country of the authority. It's just that the data is located on a server somewhere else, or the server is owned by a company that's located in another country. So this is the overall majority of the cases. These are domestic in nature. There was a lot of talk about the needs for a dialogue and information that could be provided by service providers to authorities when they make a request. That is something that, of course, is not excluded in the context of the proposal. When you are doing that today, it's quite likely that you can also do that tomorrow if these proposals are adopted, of course. And finally, there was a lot of talk about Budapest Convention as well, the main multilateral framework to fight cybercrime. The Union and the European Commission have supported the convention for many years. And this is also the case for the negotiations that are currently ongoing. So I also wanted to underline that we have proposed for the participation of the Union in these negotiations, and we were very happy to see that the Council of the European Union supported that with its decision of the 6th of June, and that from that moment onwards, the Union, represented by the Commission, can also take part in these negotiations. We are fully transparent about that. The recommendation was published on the internet. The negotiating directives are published on the internet. We think this is not something that should be done secretly. This should be done in full transparency because there are so many things at stake. So we are fully committed to that. And just a final point, because that was made by the colleague from, a comment that was made by the colleague from Google, referring to Article 18 of the Budapest Convention, which has as a scope the offering of services in the territory, and on that basis then parties to the convention can issue an order. In fact, what I wanted to point out is that the legislative proposals from the Commission have the same connecting factor. So offering services in the territory of the Union, that is the connecting factor also for the evidence proposal. So there is actually quite an interesting overlap there. Thank you.
Thank you very much. So I have 4 more people in the queue. I'm closing the queue for the interest of time, and I will collect for intervention. I see that some of the speakers want to reply, but take a note of what you want to say, and I will come back to you. So now I have Chris first.
Thank you very much. Chris from the UK. So a question for Microsoft and Google, really. So you talk about the want to be able to reduce the scope of any request or order that you've received. Obviously based on the data that you can see and you know who it might be affecting. So you're obviously saying that because you're seeing a number of those requests already. You know, I'm guessing that you're not just pulling out the hat. So how do you raise awareness for probably for the police forces and the judges to stop those orders, and then slightly tongue-in-cheek, conversely. Would you also do the reverse, where you have a request? Would you look to be open and say this probably isn't broad enough if you change the order that way? So 2 questions there. Thanks.
Right. I guess this requires actually immediate answers. So, Kadia, from you, and I'm bringing microphone to Microsoft.
So for Google's part, we try to do as much engagement with law enforcement as we can, recognizing that there's far more law enforcement officials than there are of the folks at Google who know this work. But I will say that the Spock model is the best model that we've encountered. And what I mean by that is a single point of contact who are the experts in any particular jurisdiction who understand the company, understand the data that it holds, and are very familiar with the kinds of things that can be sought and how to ask for them. So for the jurisdictions like the UK that has a Spock model, those jurisdictions do sort of, I would say, much better in terms of crafting orders that are narrowly tailored and specific in particular than jurisdictions who don't have those experts working in the field with the law enforcement community. On the second part of your question of will service providers look beyond the order to sort of do their own investigation to see if they have anything helpful, which I think is what you're asking. And the answer is no. Speaking for Google, when Google gets an authorized order to search, we search what's been ordered by the issuing authority, and we don't go beyond that. So it's our search is limited by what the court has ordered us to do.
I think I can just copy and paste the answer. No, it's we look into the orders that we suspect, and I have those examples, but which I already gave one of them. But it's the second question is a good one, but I do not have any examples of this. So I think the law enforcement are well aware of what they want. Of course, more aware than we, because we're not the law enforcement, we're not the judge who's going to decide. So no, we don't help law enforcement with their investigations. I think that would be not. Well, I can imagine that if they ask for the data, I don't have these examples, but I can imagine if you want the data from a certain from a suspect who is part of a certain domain, so to say, and you're asking a totally other domain, then you would probably say, well, the data that you request right now is not the data that you want. But I think these situations do not occur. But it's a great question. Also, little small comment on how small service providers are not able to do this. I'll make it really small. That's why we don't want to have an obligation in it, but just an option, so that small service providers are not liable when they do not object to a certain production order.
Thank you very much. And next in the queue, I have Claudia.
Hi, I'm actually a judge, so it's been funny to hear you guys talking about us. So I'm here. I'm an investigating judge in Lisbon, and I just want to be brief. And I'm happy to see that Microsoft is on the same page that we are, because one thing for us is crucial. We don't want more information than we actually need. Too much information is actually bad for us. So regarding the future production order, it will follow the same pattern as the other European instruments. It will have an annex, a template, like the European arrest warrant, like the European investigation order, and that helps a lot in focusing information. On the other hand, that's something that's been very crucial for me, and I'm very happy to be in this forum, is that we need a dialogue with companies. We need there has to be a dialogue between the judiciary, the law enforcement, and private companies, because sometimes we don't have enough knowledge, enough digital literacy, and you guys also need to help us having it. It cannot be just a role for the government, because the government itself may be in the dark. So we need to talk to each other. And if I happen to ask Microsoft or Google or another service provider for too much information, I would be happy to have an answer like the one you told me. You are asking for too much. Don't you want to focus? So we need to keep this dialogue going. And I hope to see the production order coming forward as soon as possible, because it's paramount. The judiciary and law enforcement, we are not information agencies. We are not secret service. We act in the role of democratic institutions. So we actually are the good guys. And we are here to catch the bad guys, and I'm counting on you to help us doing so. So thank you.
Thank you very much. I see that some of the panelists want to reflect. Please make a note. I will take the last two interventions, and I will give the floor to you. Yes, the next.
Hi, Catherine from the Hague University of Applied Sciences Center of Expertise in Cybersecurity. I'm in fact conducting research on what it was mentioned at the very beginning. I was happy to see that there was an acknowledgement on that within the cooperation framework we have indeed the judicial cooperation, which has been widely discussed here, but there's also been acknowledged the voluntary cooperation. So I wonder, in all the interventions it has mentioned that both have flaws and also that have not been working perfectly. However, my question goes back to the voluntary cooperation framework, and I would like to know what kind of measure or what kind of indicator you take into account to measure success or failure of these non-voluntary frameworks of cooperation.
Thank you very much. And I will take the last question and the last intervention, and then I will just give it to the panel, and you will reflect on whatever you want to reflect upon.
Thank you very much. My name is Michael Rothärmel. I'm working at EuroJust, just across the street. And it was very interesting to hear all those various perspectives, judiciary, law enforcement, companies, researchers. And I would just like to very briefly add one more, and that's the perspective of the coordinator, because that's what EuroJust is doing. We are coordinating cross-border investigations to make sure that judicial authorities can cooperate in a sound way and don't get into each other's way when doing investigations of linked cases. And linked cases is what you usually have when you talk about cybercrime, which is in the title of this session, or cyber-enabled crime. You have victims in very many countries. You have the way the criminals themselves are distributed over many countries, the way they provide crime as a service to each other. And this is a huge challenge, and it makes it very complex to address. And for that reason, I think it's a step with a great potential that lies in the EEvidence package, and also in what the Council of Europe is doing, that we are at least trying to find ways to not involve those states that are not really having a substantial connection to a certain case. This is a little bit echoing what Marco has described. Why would we also need to involve states just out of the pure coincidence that a service provider that is relevant, that holds relevant evidence, is located in that state, or that data is stored on that state's territory? So, and I think the EEvidence package has the potential to make a real step forward in that regard. The more so as it doesn't. It is difficult to think of other states that could play that role. So which would be the relevant state to make a decision? The state where the data subject resides, most of the cases you will not know where that is. So I think the right way forward is that you try to compensate this, as it was called, taking away of that layer, by creating additional strong safeguards on the side of the issuing state. Just to add this from the perspective of the coordinator.
Thank you very much. And before I will give the last word for this session to our speakers, I would like to sum up a bit. I see that for now we really have a bit more questions than we have answers, and we do have strong disagreements. And while I'm very happy that we have such a diverse stakeholder panel here, law enforcement, academia, civil society, providers, I think that this discussion could have been much broader, like including, for example, lawyers, bar associations, and so on and so forth. And we have limitations here at EuroDIG. And I know that we were going to wrap up talking about the next challenges, but I think that the entire discussion, it is already on the next challenge. So I will just give the microphone to all of you to maybe lay out the challenge for you, and also to reflect on anything you heard here, to answer the questions. And I will start with Philip.
Thank you, Tatiana, and I agree with you. I think that was a very interesting discussion, and we could have spent much more time on that and include many more people and get many more opinions, and that's important. Just before I start, I just want to say the Microsoft statement was under my name, which I don't really care, but you said things like you don't support law enforcement, the role to support law enforcement. I just said this was not me, this was you.
For the record.
So I don't get back to my office and my boss tells me thank you. The other thing is, and it goes very much, just to explain that, Europol EC3, we are also not European FBI. We have a coordinating role. We support member states. I think that's important also, as you said, Michael. So that's why we're in a very strong position, because we see the issues, and we can hopefully create this network of networks that to provide an answer. And that brings me to one of the points. I don't know who said that now. So one of the things we do is we work very closely with industry. We have advisory groups for the internet security community. We have an advisory group for communication providers. We have an advisory group for the banking sector, financial sector, and that's public-private partnerships plus participation, which we always like to add. This is key for us because then we can understand what are the issues. And for instance, 2 days ago, we had the second meeting this year with the advisory group on communication providers, and it was all about 5G. I mean, it's great, that's going to be a revolution, but, law enforcement is not really considered in the development of standard. And we have then this forum where we can discuss this with experts. And the same goes for, all the other challenges. And for us, this is a great forum to hear the other side and see where is the common ground, and we can explain our views, and equally we get back the view from industry or the communication providers. So these are the challenges, and that's vital to us. So I really subscribe to that. It can only be a networked approach. I mean, we have to have, as a society, we need to come together to address those issues. It's up to law enforcement to say this is how we do it, or the judiciary, or a company for that matter. I don't think companies should set the reality, which they sometimes do when they implement the technical solutions. That this is it now, and without involving sort of the broader discussion around that and say what are the implications of that. It's great to have this very strong focus on privacy, but from where we stand. Privacy, security, safety, this is not a zero-sum game. This is something that has to go hand in hand. And cannot cut out law enforcement, you cannot cut out the judiciary and just solely focus on privacy, because then you're missing that safety and security part. So we need to talk, we need to create this network, we need to have this mutual understanding of the challenges and the needs and the requirements, and I think that's the way forward to solve these problems that we face. And I think just to end with, so what are the challenges? So I think I highlighted some of the key challenges. 5G, if I want to be very specific, 5G is definitely going to be one. Encryption, the criminal abuse of encryption, certainly one of our key challenges. Big data volumes. So the fact that the volume of data that we sometimes get, for instance, in the area of child sexual abuse, this is no longer something that we can solve with human resources. So we also need to look at technology, and I think we didn't get a chance to talk about artificial intelligence. I don't particularly like that term, but it's things like machine learning. How can we use technology to improve cybersecurity, but also to help law enforcement and judiciary? So I think it's going to be very, very exciting. We'll definitely look at technology also to help us solve some of the issues, to make sure that we get the best out of cyberspace, that we can use the benefits of technology, of digitalization. Make sure that, again, we work together, have safety, security, and privacy all together. Thank you.
Thank you. Marco, you're the next.
Okay, I think that if you just look at the statistics everywhere, then you can see that the number of cybercrimes and cyber-enabled crimes is increasing. And the problem is that often actually perpetrators, criminals behind those crimes, they just get away with this, because the very low rate of detection, sometimes also low rate of successful investigations. This is something actually that has been also facilitating this situation. So therefore, we need something additional. We would need those new legal frameworks, EU proposal, EU regulation, and the second additional protocol to the Budapest Convention to improve the situation and to facilitate access to computer data, because this is what we need. A colleague from the Commission already mentioned that before Commission came out with this draft proposal, they made quite extensive work, and then also they drafted quite, let's say, comprehensive explanatory report. As regards Council of Europe and draft second protocol to the Budapest Convention, then the situation is a bit different, because we don't have the draft text. And because all the drafting and the negotiation is being done in a bit different manner, but still we have plenty of information and then background information, different reports, studies that were carried out by Cybercrime Convention Committee, and this information is also available on the Council of Europe website. But still, right now, the Cybercrime Convention Committee is working with the draft text, just quite, let's say, slowly, let's say, article by article. Every year also we try to have some sort of public hearings, also meetings with other stakeholders, industry, law enforcement, civil society, data protection. And this year, actually, we will have Octopus conference in November in Strasbourg. And again, there will be not only one, but several workshops dedicated to the protocol and issues that are being addressed there, including the elements and also conditions, safeguards. Actually, most of the things and then most of the points and then concerns that were raised here today, these are the issues that we are going to discuss in Strasbourg as well. So you can also, although we don't have the text and then it's not so easy actually to follow the negotiations, discussions, and then provide oral or written comments, but still there is some information which is already available, already actually the elements for the second additional protocol. And then background information, also explanations why we have come to a situation like this, and what are the reasons. So this is something that you can use. Also, as regards, let's say, different frameworks, then also we have already realized that EU has a specific, let's say, ecosystem, I could say. Mutual recognition principles, Charter of Fundamental Rights, GDPR, and then all these other standards as well, procedural law and then substantive law. That means that for the second additional protocol, the discussions are also a bit different, because even if we can agree certain principles at the European Union level, then we need to think actually how this would work with third countries as well. Because as I mentioned, when it comes to the protocol, then right now we have 63 state parties, and the solution actually has to work for everybody. So that means that conditions, safeguards, notification, so everything needs to be there as well. And we don't know yet actually when we would finalize the text of the protocol, but we hope that that they would arrive quite soon.
Thank you very much. And Stanislav, I saw that you wanted to answer European Commission intervention, and maybe you can wrap it up from your perspective as well.
Mm-hmm. Yeah, I would like to react to what Csaba Bosz from the Commission said. I acknowledge the huge work that was done by the Commission. I was observing it as it was developing, and it was great work and great effort. There is no doubt about it. I acknowledge the creativity of this instrument, but hard work is not a guarantee of perfection or of a great result, unfortunately, and it doesn't mean that there are no flaws in the system. And I would like to, you made several points, and I would like to respond to 3, because I think there needs to be a response to that. You said safeguards are harmonized in the EU. No, they are not harmonized. Some of them are harmonized. There is the roadmap. Some of them were harmonized. For example, access to a lawyer. Okay, this is important, but this is not crucial here. But problems that we discussed were not subject to harmonization. Not to mention the substantive criminal law, which is also a problem. What we discussed, what you mentioned about abortion, I believe. So we have plenty of problems where harmonization is non-existent. So I don't think harmonization is a solution here. Then you said that there are a lot of remedies, there are conditions, I agree. Some of them higher the threshold in comparison to national law, possibly. But in terms of remedies for person concerns, we have a chapter on remedies. There are 3 articles. Out of those 3, 2 are about conflict of law. They are only for the service providers. And 1 is for the persons concerned. What does it say? This is for the member states to legislate on that. And for the suspects and accused, it's limited only to the member state that is investigating and prosecuting. If you call this a lot of remedies, then I don't know what it means to have a lot of remedies, but I don't think that. And the third point, you said majority of the cases will be domestic. Fine, but there is also the minority, where all these problems will be exacerbated People will not even potentially know that what's happening in another member state and concerns them, and there will be requests for data, and they might not even know about it. So you cannot use an argument, in my opinion, that majority will be fine if minority will not be. If majority will be fine as well, that's another question. But I don't agree with this. Of course, the whole problem started with domestic cases. We know that with cases like the Belgian Yahoo case, which were domestic, and then law enforcement couldn't get the data. But then this proposal creates a system which is broader than that. And I think all these consequences should be thought through to the end.
Thank you very much. And I hope that you can stay here for another 5 to 7 minutes so we can really wrap up this wonderful discussion. Paolo,
yes, I would be very, very brief. As I said, the discussion just showed that we are in a single market in the European Union, but criminal law is not harmonized. And the direct access to providers in other member states can make up only partially to the lack of cooperation and also trust among authorities that is also at the origin of this kind of proposal. But there are developments in place. For example, we have a newish European investigation order, so it would be very curious to see how it gets implemented, and maybe a few years down the line that may show that the need of an e-evidence proposal was not that big as it was originally foreseen. But also I would be very interested to understand how in the eyes of the legislators and the decision makers, the e-evidence proposal ultimately needs to be implemented, because we are talking about principle, which is right, but in the end there have to be a legal and technical solution to be put in place, either via a centralized system or a network of spokes, let's say. But this is a discussion that seriously needs to be tackled, and maybe eventually we do understand that the technical solution that will be in place would also promote more cooperation or smoother cooperation among authorities of different member states, or would require eventually more cooperation among authorities in different member states. And then we are back to square one, that what matters really is government-to-government cooperation.
Thank you very much, Anakadia. You really we made you waiting for quite long, but you will be last but not least.
No pressure. No, thank you. Just one quick reaction to the Commission. First, the Commission should be commended for its stakeholder consultation process, which absolutely was thorough and very much welcomed, and one of the more extraordinary that we have seen occur. So. Thank you for that. One point of clarification on the Article 18 jurisdiction provision with respect to the Budapest Convention. It is true that the Commission's proposal with the e-evidence regulation borrowed from the Budapest Convention's Article 18, but the regulation eliminated important requirements of Article 18, and I think that bears mentioning because the elimination of those requirements fundamentally changes the jurisdictional provision of the regulation as compared to the Budapest Convention. But summing up, I think, and I've said this to some colleagues and really anyone who will listen, I can't remember another time when there were so many legislative proposals on the table that implicate cross-border access to data. And it's very much welcomed. This is exactly what we need in terms of lawful access to data, in terms of developing frameworks with safeguards, with harmonization, with proper procedures and safeguards. And so I think this is actually a very exciting and frankly crucial time with respect to e-evidence, with respect to the Budapest Convention, with respect to the Cloud Act, with respect to the EIO, to see how it develops. And I think it's an important time to ensure that it's a moment to elevate privacy protections and safeguards in this space, but it's also an important time to ensure that these frameworks are harmonious, that they do the things they intend to do with respect to resolving conflicts of law, and that they are cohesive. So looking forward to those discussions.
Thank you very much. And before you wrap up, actually there is one person in the room I don't envy, and this is the reporter of this session. I really don't know, because as a moderator, and I know the topic, and honestly, I will not be able to draft the messages, so I'm wondering what the challenge here is.
Well, if I could sum this up the way I want to, it would be very exciting and frankly crucial, to quote you. Yes. We discussed a lot of things today. It was very, very dynamic. The way this works is that I read the messages and you tell me if you strongly agree or strongly disagree. The messages will be up for voting later on by the community, so there will be changes. Changes will be possible. So we said that a lot of discussion revolved around government-to-government interaction. So instruments that involve government-to-government interaction are preferred by some of the actors, stakeholders, in order to ensure that the fundamental principles of human rights are respected. Does anyone have a real pushback on that? That is fine? That is fine? All right. We also said that the law enforcement are the good guys, or that we should all collaborate. So raising digital literacy in law enforcement and judiciary, including prosecution judges, and also telecom operators is crucial. That's all right. And then we said that it's very important for the second draft protocol to work for everyone, including non-EU countries. So conditions and safeguards and notifications have to be present. I have room for 2 more messages. Now that is possible. I don't know how long you want to stay here for, or if we can agree on 2 things, or if you're all right with these 3.
I actually think that this message would be ready for comments. So if there are additions, if there are other points to raise, you can always raise them. And with this, thank you so much. And thanks so much to our panelists and to everyone who contributed to this discussion, who were not on the panel. And yeah, thank you. And my amazing co-moderator.